All right, everybody. Looks like we have critical mass here. Thank you so much for joining today. We're excited to hear from our partners over at Kirton McConkie. They have some really interesting and important information for us on the Foreign Corrupt Practices Act, and super relevant for anyone who is in aerospace and defense and doing business with international entities. So I'm Robert Carroll. I'm the Chief of Staff at 47G. We are Utah's Aerospace and Defense Association. I wanted to share just a quick few slides about what we do here, and we would love to have you reach out after the webinar, during the webinar, through our website, and we'd love to get you plugged in if there's any work that you're doing in aerospace and defense. So aerospace and defense in the state of Utah is 20% of our economy. So up and down the Wasatch Front, we have great companies, military installations, universities, research centers that are affiliated with NASA, with the Air Force, with other great national institutions. And so we do quite a lot of aerospace defense and cyber work in Utah, big part of our economy. And these are some of the companies that have joined 47G as members that we get to work with on a daily and weekly basis to build the world's premier ecosystem for aerospace, defense, and cyber companies. So we're extremely industry focused. An important part of our industry is having the right advice and the right counsel from firms like Kirton McConkie. And so we're looking forward to their presentation today. I'm going to quickly share the bios of the gentlemen we have here on the webinar with us. So first, I'd like to introduce Matthew Pruitt. He's a member of the firm's corporate section with a practice focused on corporate law, contracts, litigation, judgment collection, entertainment, IP, estate planning, and real estate. He's argued before the Ninth Circuit Court of Appeals, and he's a background in the entertainment industry in management and agent positions, including for the Killers and Imagine Dragons. So really interesting experience there. He's barred in the state of Nevada and in the state of Utah. And so thank you, Matthew, for being here. Ammon Hansen, who's going to share his slides soon. Thank you for being here with us today. He's a member of the firm's international section, where he helps guide companies on international business matters involving international trade, export controls, enforcement matters, due diligence efforts, sanctions, and disputes. Prior to joining Kirton McConkie, Ammon Hansen worked as a legal director and senior trade counsel at one of the world's largest defense contractors, advising on global trade and compliance matters, including ITAR, EAR, and FCPA, which is what we're talking about today. So thanks for being here today, Ammon. And then finally, Theo Smith. He's a member of Kirton McConkie's corporate section, where he focuses on M&A, business contracts, entity formation, antitrust, public securities, and FINRA compliance. He's a member of the firm's international section as well, where he focuses on topics like EAR, ITAR, and today, FCPA. So I will turn the time over to Theo. Again, thank you, gentlemen, for being with us here today. I think our group on the call, which is a good group, will gain quite a lot from the discussion. Thank you.
Thanks, Rob. Happy to be here. We can go to the next slide. So today...
Can I add, Theo, sorry, can I just add one more thing? We do have the Q&A open. And so if anyone has questions along the way, feel free to type those in.
Great, thanks, Rob. Yeah, feel free to ask questions now in the chat or at the end. Yeah, so today we're going over the Foreign Corrupt Practices Act. I'll begin with a brief overview, short history, and then go through the bribery component of the act. So it was passed in 1977 in December. It covers accounting transparency and also bribery. So I'll begin by going over the jurisdiction. As you can see here, it applies to what the act calls issuers and domestic concerns, which, as you'll hear, covers almost everyone now. Issuers technically applies to registered companies, think public securities, public companies. Domestic concerns covers all business entities, corporate entities that are headquartered or formed in the United States, and includes individuals as well, citizens, U.S. nationals or residents. Originally, there were some loopholes here, as you can imagine. You know, what if you're not a citizen or a resident, but you show up to the U.S. and you want to, make some bribes? If you go to the next slide, Ammon. So as you can see, there was an amendment to the FCPA a little over 20 years later, which attempted to close some of those loopholes and significantly expanded the jurisdiction of the U.S. government in prosecuting and enforcing the FCPA. So today, the Department of Justice and the Securities and Exchange Commission are jointly responsible for enforcing the FCPA. So what this 1998 amendment did was close some loopholes regarding people who are visiting the U.S. who didn't fall into some of those original categories. So that would include someone who is, let's say, stopping in the U.S. for a layover flight, going somewhere else, and while they're at the airport, they make a bribe, right? So after this amendment, they can be prosecuted because the bribe took place on U.S. soil. This amendment was also aimed at bringing the enforcement of the FCPA and its scope in accordance with the OECD's Convention on Combating Bribery, which was meant to make it a more consistent approach in terms of how the U.S. interacted with these international issues. If we go to the next slide, Ammon, there's another part to this amendment. So there was another loophole in the original FCPA which allowed U.S. domestic concerns, so think U.S. companies, to engage in corrupt practices and to make bribes overseas, if the money was happening, beginning and ending overseas within foreign entity branches. So, but this amendment closed that. So if the company has any kind of nexus to operations in the U.S., any kind of formal corporate relationship to a U.S. Business, then the U.S. federal government would be able to prosecute those companies for actions that their employees or agents or international branches undertook, and for bribes made overseas as well. So that includes payments, like I said, that don't involve interstate commerce. So the money could originate overseas and then go to someone else overseas, and you can still be prosecuted by the government for those bribes and those actions. So the amendment significantly expanded the jurisdiction. It made the act more consistent with the United States overall international framework for tackling these issues. If we go to the next slide, Ammon. Now I'm going to run through some of the basic elements that the government looks at when making a claim against a business or an individual for bribery. Like I said, there's some other parts of the FCPA, but this is just going to be focusing on the anti-bribery provisions. If you go to the next slide, Ammon, we'll get started on that one. Great. So obviously, to make a bribe, you have to offer something. It doesn't have to be money. That's important to know. It can be an offer. You don't have to actually hand over the money. So payment, an offer, an authorization, or any kind of promise of money or anything of value, including through third parties or intermediaries, can satisfy this element and get you on the hook here. So examples of anything of value would include information, testimony of a witness, promises of school enrollment, always a hot topic, or employment. There's no de minimis exception, which means that, if this so-called bribe or anything of value is very small or insignificant in your mind, well, if the federal government decides that, they become aware of it and decide that you satisfy these elements, they can still prosecute you and attempt to enforce the FCPA. So, yeah, important to keep this in mind since there's no de minimis exception. You want to go to the next slide, Ammon? Okay, so this is where it gets interesting. So when you're offering something of value, who are you allowed to do it to and when? So to constitute bribery under the FCPA, it goes to typically a foreign official, a foreign agent, or an employee of an international organization. So you can see here, there's a different list. You can run into problems with donating to any kind of foreign political party or campaign fund. You got to be careful with that. The intent and the motive and the purpose of donating to foreign political parties or state-owned companies or public international organizations matters a lot. The identity, the correct identity of the recipient of the bribe doesn't have to be known or correct. So this is a pretty interesting one. So there was a case in New York where someone attempted to bribe a broker to obtain some business, and the broker represented, told the would-be briber that he was representing this other foreign official. And it turned out that the broker wasn't. He was lying. He just kept the bribe, and he completely lied about who he was and who he worked for. And the person who made the bribe still got prosecuted under the FCPA and convicted. So because the intent was there and the payment was made, even though the recipient wasn't falling into the concrete literal definition of a foreign official, the FCPA enforcement was still triggered. And then the very vague and broad offers of bribery to pay whoever you need to without knowing exactly where the money's going, that still counts. That still satisfies this element. So you can't say you didn't know who exactly the money was going to. So you've got to be careful there. You can't wiggle your way out of the enforcement with some constructive ignorance there. And on the flip side, of course, the government, when prosecuting, can use constructive knowledge to say that you knew what you were doing here. So the element here can be satisfied as long as you have the intent and the understanding on your side that what you're doing is violating the act. Yeah, and then the last note, the FCPA is aimed at enforcing against the people who make the bribes, not the recipients. So that's kind of interesting. If you want to go on to the next slide, Eamon, we can tackle the next element. So this is just looking at the means by which the bribe happens. Typically, it's interstate commerce. But as we noted with the 1998 amendment, technically that isn't always the case. So it could be acts outside of the US, it could be acts inside the US. It doesn't have to be through a bank wire, like we said, it could be an offer or promise, which can come through any sort of means of communication, in person, email, you name it, Twitter. And then, yeah, the last note, I guess, acts in furtherance of the bribe. Like we said, you don't have to actually complete the bribe itself or the offer of value. You want to go on to the next slide, Eamon? We'll hit number 4. Thanks. So this one's pretty interesting. When is someone's motive corrupt? When is your intention corrupt versus when is it pure? So this is a little more nuanced. The term improper advantage it shows up in the act here. So there's a lot of different factors that go into determining when something is corrupt or improper. It typically involves influencing the act of the foreign person in giving business or retaining business with the person making the bribe, but it's not always technically business, right? It could be in exchange for personal benefit, perhaps. Another important note is that the bribe doesn't have to be intended to make the other person do something. It could also be to bribe them to not do something, right? So to make them deviate from their ordinary course of lawful business. So anything that would make them deviate for that, for your benefit, would probably land you in hot water for satisfying this element of bribery. And it's typically related to the foreign person acting in their official capacity, which would make sense, although it does involve private business as well. Down here, this note, corruptly, like I said, very nuanced. This is a helpful quote: voluntarily and intentionally with an improper motive of accomplishing either an unlawful result or a lawful result by some unlawful method or means. Fancy way of saying that what I just tried to explain. And again, constructive knowledge comes into play here. So you can't just tell the government, you know, I didn't have a bad feeling about it, so it's not a problem. Eamon, you want to go on to the next slide, then take a look at element 5. Yeah, and this is what we talked about. It's typically for obtaining or retaining business. So you can already have a lawful relationship with the foreign counterparty. You know, you're already doing business, you already have an arrangement that didn't violate the FCPA, that didn't violate other laws. And then in furtherance of what you're doing, it's possible to violate the FCPA if you suddenly make a new payment or offer that satisfies the bribery elements. And there's some exceptions, which I think Eamon will mention. But it's important to know that the FCPA in general has a very broad jurisdiction now. These elements can be very broad and nuanced. So just in general, you know, watch for red flags, stay away from bribery. Here's a recap: 5 elements: payment or offer of anything of value to foreign officials or agents, usually via interstate commerce, but not necessarily. It basically impacts all U.S. residents, nationals, companies, visitors, and also overseas businesses that have any kind of nexus to the U.S. Willful intent with a corrupt motive, element 4, and then an improper advantage in retaining business or obtaining business. So those are the elements of bribery under the FCPA, and I'll hand off the time to Eamon to continue with some more of the factors here.
Thanks, Theo. I've got up here just an overview. Theo's done a nice job here of walking us through the bribery, the elements of FCPA and bribery. And I'm going to focus now, as Theo just mentioned, to some of the exceptions and the affirmative defenses to FCPA bribery. And then I will jump into the record keeping and internal controls aspect of the FCPA. Once I'm finished with that, we'll talk a little bit about other laws related to FCPA, as well as some other international resources. So that's the portion that I'm going to cover before turning it over to Matt to talk to us about sanctions and some of the headlines that we may have read recently and issues that companies have encountered with FCPA noncompliance. Okay, so the first one that I'm going to talk about here, the first exception, is facilitating, expediting grease payments. Those are all kind of different words or descriptions for the same thing. I think the one I think is most descriptive, or probably best, is expediting. And you'll see here from the next slide as we talk about what a grease payment is, or an expediting payment. They are small sums to facilitate routine, non-discretionary government functions. If you're dealing with large sums of money, you're probably not dealing with an expediting, facilitating, or grease payment. I like to think of these as payments that are made to move things along. They're not payments made to change decisions. They're not payments made to skip things, to skip requirements. They're payments made to kind of expedite things and get them moving along. So examples of expediting or facilitating payments could be payments made to kind of move the process for permitting or licensing or getting visas or work orders, moving those things along. It's not to skip steps. So if you have a requirement for an environmental impact statement or something like that, or another hurdle that has to be done, paying something to make that go away doesn't fall under this exception. Other examples is the providing of services or provisions. So, for example, police protection, power, water supply, those types of things. And the third thing is scheduling inspections related to contract performance or the transportation of goods. These are not payments to skip the inspection. They're just payments to get the inspection scheduled. Maybe move your inspection to the top of the pile, those types of things, just to get things moving along. Does not include awards for new businesses or to retain business. And it is worth noting that the UK Bribery Act prohibits facilitating expediting grease payments. So if you're doing business anywhere where the UK Bribery Act is applicable, be aware of that. And the UK Bribery Act has a broad reach, much like the FCPA. So even if you're not necessarily in the UK, you could still be subject to the UK Bribery Act. Another affirmative defense is the written laws of the foreign country. So if you can show that the payment that you made, the gift, the offer, the promise, whatever, was lawful under the laws and regulation of the foreign official's country, that would fall under that exception. Just of note, as is written in the slide, there aren't country laws that permit bribery. And it's also important to note that the absence of a law doesn't meet this exception. So if a country doesn't have a law that prohibits bribery, this exception doesn't necessarily work for you. You need to actually point to a law that covers the conduct that you're engaging in. So just a couple of points to think about there. In the materials that the Department of Justice provides, they provide examples from cases where this was used, and I believe in every one of them, it was denied by the court. So they don't provide a clear example of when this has been successfully used, but it is an exception. If you can point to it, to a specific law, then this could apply. All right, the next affirmative defense to talk about are the reasonable and bona fide expenditures. And this is probably the portion that you'll want to pay some close attention to, because this gets into what is reasonable and what is a bona fide expenditure that could be paid. So I've got a few slides on this. The FCPA does allow payment of reasonable and bona fide expenses for things like the promotion of your products, the demonstration of your products, explanations of products and services, those types of legitimate business reasons that you have, those expenditures can be paid. However, things like trips, personal entertainment, those are not necessarily bona fide expenses and may violate the FCPA. As you can imagine, this is a very fact-specific analysis. You have a potential customer coming over to visit your company for a demonstration of a product, but that trip is coupled with dinners and other events. You have to look very closely at the individual facts to determine whether you have a potential violation of the FCPA. And the other thing that we're going to talk about in more detail in a few minutes is that you make sure that you properly characterize those expenses in your books and records, or you may have another FCPA violation for a books and records violation. Now, the Department of Justice has opined that there's several categories that don't in and of themselves violate the FCPA, and you'll see that all of these are legitimate business expenses, travel and expenses to visit company facilities or operations, training, product demonstration, promotional activities, those types of things are all legitimate. But as I just mentioned a minute ago, couple that with dinners and other things, and you have to closely analyze whether what conduct you're engaging in and expenses you're paying for violates the FCPA. So here's some helpful guidance that the Department of Justice has provided on just some potential criteria to look at when you're trying to determine, whether you've got reasonable and bona fide expenses. So number one is don't select the officials and use merit-based criteria. I think on the first point, when you select which government officials you want to come over, you may not be selecting the one that's the right person within the government to make the decision And so allowing the foreign government and those individuals to make the decision as to who the appropriate person is to come over for, or to be involved in a trip or a visit, that's the safer road than having us as the U.S. companies make those selections. If we are involved in the selection making, using merit-based criteria to make that determination. Number two, requiring receipts. And that's the picture I started with at the beginning of this section was the thing that many of us have to do from time to time, take pictures of your receipts and submit expense reports. You should be doing the same thing if you have individuals from foreign countries visiting and you're reimbursing expenses. Require receipts just like you would have to do in an expense report. Don't advance funds or pay for reimbursements in cash. Make sure that stipends are necessary and reasonable. I know many companies have a whole system of what's a necessary and reasonable stipend for different cities in the country. Is the stipend being provided necessary and reasonable? And one of the keys to all of this is just transparency. Is what is being spent, the purposes and everything transparent so that all sides can see the purpose and why money is being spent. The next bullet point's a key one. Don't condition payment on action by officials. We'll pay for X if you will do the following. That is clear red flag for FCPA non-compliance. Confirm your payment is not contrary to local law. So, for example, I mentioned a couple minutes ago the UK Bribery Act. Facilitation payment may be illegal under that. So if you're doing business in the UK or somewhere else that is would be subject to the UK Bribery Act, be aware of those. And many other countries have their own anti-corruption laws that you need to ensure you're in compliance with. And then once you've set up all these good compliant measures, don't provide additional compensation, stipends, or spending money beyond what your company policy allows for. That's another red flag. And then, as I've mentioned before, accurately record in your books and records what's been reimbursed, what stipends were, all of that, so it's transparent and clear, and you don't have another books and records violation. So now, I've mentioned it a couple of times. Let me now move into the record keeping and internal controls portion of the FCPA. All right, so maintaining books and records. And as you'll see from the slide, issuers are required to keep books, records, accounts in, and the key word here is reasonable detail. You'll see in the second bullet point below, reasonable detail is the level of detail that would satisfy prudent officials in the conduct of their own affairs. So that's what officials would be looking for in your books and records. And then to go back to that first bullet point, reasonable detail accurately and fairly reflect the transaction and dispositions of the assets of the issuer. And so if a official is looking at whether your books and records and your internal controls are reasonable, there is a weighing of a lot of factors that they're going to look at, including the cost of compliance. So you're not necessarily expected, if you're $1 million company, to spend $1 million on compliance. They are going to look at the cost of compliance. So there are several factors that they would look at. Key thing is never mischaracterize transaction in companies' books and records. And just like you heard from Theo a few minutes ago on the bribe amounts, there's no materiality threshold, and any value in your books and records can constitute a violation. So that is the books and records recording portion, and then there's also an internal controls portion. And these are really the processes that you use as a company to provide reasonable assurance of the reliability of financial reporting and financial statements. There isn't really a particular set of controls that are required for every company to follow. Each company has unique and individual aspects of your business. And so there's some flexibility in determining what those internal controls should be for your company, but you need to have a set of internal controls and maintain those. Components of that could be risk assessments, could be policies and procedures, the whole tone of the organization. Do you have a tone from the top of compliance and honesty and integrity and transparency? And does that tone kind of flow through your policies and procedures and your assessments? Do you do regular audits? Those types of things could all be aspects or components of what you are looking at in this internal controls section. All right. So let's talk for a minute about other related U.S. laws. So we're now moving on to outside of the Foreign Corrupt Practices Act. A lot of times, if you read in the news headlines, you'll see that not only was Company A pinged with a FCPA violation, but they were popped with other violations. And these are some of those violations that you could encounter. One is the Travel Act, which prohibits travel or the use of mail or other facility in interstate or foreign commerce with the intent to distribute proceeds of unlawful activity or to promote, manage, establish, or carry on unlawful activity. So that's an act that some may not be aware of, but you can violate. And then you'll see a couple of common ones you've probably heard or are very aware of: money laundering, mail and wire fraud, tax violations. When you're in the business of making bribes, money laundering and tax violations are very common. And because the group today is aerospace and defense, I want to talk about the fifth bullet point: certification and reporting violations. And these would be violations of the Arms Export Control Act or the ITAR, and the ITAR. I wanted to break this down in a little more detail. So ITAR Part 130 is a section of the ITAR that deals specifically with the payment and reporting of fees and commissions to representatives and consultants. So if you're involved in the sale of defense articles or defense services valued at $500,000 or more that are being sold for the use of the armed force or foreign country or international organization, this would come into play. And under the ITAR, under ITAR Part 130, you have to report fees or commissions paid to representatives and consultants who engaged in the solicitation or promotion of the defense articles. And kind of the threshold amount for those payments is $100,000. So if you've made payments in those amounts, ITAR Part 130 could come into play. And it's going to come into play if you're a supplier or an applicant. So if you're submitting, and if you've submitted licenses to state, you've seen the ITAR Part 130 section in the application where you have to report fees or commissions paid to representatives or consultants. If you're a supplier, like on a foreign military sale, there are requirements for reporting these too. So really important section. And if you've looked at some of the consent agreements that have come out from state over the last 10 or 15 years, ITAR Part 130 is a significant, often is one of the significant portions of the ITAR that gets brought up for noncompliance. And it really goes hand in hand with the ITAR with the FCPA, because you're looking at fees and commissions being paid to reps and consultants, which often has links to the Foreign Corrupt Practices Act. All right. Oh, and the other thing that at the bottom of that slide is there's strict deadlines in the reporting of those, if it's DCS sales or FMS sales or otherwise. So you'll want to make sure you're familiar with that and seek legal advice if you have questions on making those Part 130 reports. Going back to the Foreign Corrupt Practices Act, the Department of Justice, as I think Theo mentioned, and the Securities and Exchange Commissions are the agencies that enforce the FCPA. DOJ does criminal enforcement as well as civil actions, although the SEC is the one who engages in civil actions against issuers and officers, directors, employees, agents, or stockholders on their behalf. So those are who does the enforcement. Now I want to spend just a couple minutes to talk about a couple of international anti-corruption groups. The first one is the Convention of Combating Bribery of Foreign Public Officials in International Business Transaction. This is a legally binding international agreement. It's been ratified by 45 countries. As I recall, the last time I looked, I think the most recent country ratified it in 2017. So it is still can be ratified by additional countries. Came into being in 1997, and it's really an agreement to establish bribery laws, making sure they're a criminal offense, and then investigating them and giving some teeth to those bribery laws. As I think Theo mentioned fairly early on, laws tend to prosecute the briber, not the one receiving the bribe. And this is referred to as the supply side of bribery. So focus for most laws and most of these conventions is to look at the supply side of bribery. And then the OECD Working Group on Bribery monitors countries' implementation of anti-bribery convention agreements and making sure that they do what they are supposed to do. The second group that, in conclusion here, that I will talk about is Transparency International. And perhaps some of you are familiar with Transparency International. They do a corruptions perception index report, which reports on the perception of corruption in specific countries. If some companies use this Transparency International index to assist with their due diligence and other anti-corruption efforts, so it's an excellent group that provides this ranking or score, I guess is a better way to say it, every year. Here is a list so you can kind of see top to bottom those with the best perception of anti-corruption and those with the lowest. So you can see Denmark does very well in the top left corner, and Somalia, Syria, South Sudan round out the bottom of the list. Just for interest, you can see the United States made it into the first column, although we have a little ways to go to hit the scores of Denmark and Finland and New Zealand and some of those other countries. But this is always interesting to look at and to just see if it'll let me go back up. Yeah, to just kind of see on the map here where those different countries are. You can see that North America, Europe, Australia, parts of Asia do pretty well. And then we've got the other countries. They're kind of more in the middle that are darker in red. So these are all pretty helpful to utilize as you're doing due diligence and looking at where your business partners may be. So with that, I am going to turn this over to Matt to round out our presentation.
Thanks, Eamon. I'm going to be presenting here on penalties and on the current events, things going on. If we can jump to the next slide there, Anna, that'd be great. There should be one right before that. Okay, well, we'll go ahead with this one. So in enforcement, when you're dealing with the DOJ and the SEC, there's different tools that they use for enforcement. A lot of times they'll communicate ahead of time with the companies that they're targeting, and they'll enter into things like plea agreements, deferred prosecution agreements, which is where they actually file a case against the company, and then they monitor the company usually for a period of about 3 years. And if the company makes the changes that they're requiring, they'll go ahead and strike an agreement with them. There's also declinations where they may even decide not to pursue a company at all. And they'll consider in that the nature and seriousness of the offense, the corporation's history of offenses and their willingness to cooperate, and remedial actions that the company's taking. One of the big things that we need to look at is is self-reporting. Self-reporting, the DOJ's policy on that is to recommend a 50% reduction in fines. So that can be a significant reduction in fines by just self-reporting. And then the company also usually doesn't have to deal with monitoring if they self-report, which can be pretty onerous when the DOJ sets up a monitor to basically somebody that's going to sit inside the company and monitor everything for often several years. Hammond, do we have the penalties slide? Okay. So these penalties can be pretty steep. For anti-bribery violations, we're looking at $250,000 per violation for individuals, or $2 million per violation for corporations. Accounting violations, $5 million and $25 million. And for individuals, they can also face jail time, 5 years for the anti-bribery violations and 20 years for accounting violations. Now, these violations can get even larger with SEC's disgorgement of profits. If a large company has profited greatly off of some of this bribery, $1 billion, the SEC can disgorge that and take that back. And then the Alternative Fines Act allows even greater fines, which basically allows the DOJ to collect 2 times the amount of pecuniary gain, which is usually 2 times disgorgement. And then there's other, civil and government penalties as well. But needless to say, these fines and penalties can escalate into the millions or even billions in some cases. Go ahead to the next slide. All right, and talk about some current enforcement activities or recent enforcement activities in the headlines. Going over, we're looking at mostly some large awards here and large companies, but I don't want anybody to feel too comfortable if they're not as large as these companies, because they look at everybody. With regard to Airbus bribed foreign officials to obtain and retain business and to sell aircraft. Their charges stemmed from willful failure to disclose political contributions, commissions, or fees as required by ITAR. And then they were engaged in a multi-year massive scheme to corruptly enhance their business interests in China and other places in the world. They ended up paying almost $4 billion, with $2.3 billion going to France and around $1 billion going to the UK. This was a worldwide effort that really was the biggest collection for bribery in the history of the world. Around $582 million went to the US, with half of that going to settle the FCPA charges and half going to settle the ITAR charges. Goldman Sachs, they created a subsidiary that was meant to bribe high-ranking officials in Malaysia and Abu Dhabi. The bribes enabled Goldman Sachs to obtain business from 1MDB, a Malaysian government-owned investment fund, including underwriting of approximately $6.5 billion worth of bond funds. The SEC found Goldman Sachs had violated the anti-bribery and internal accounting controls and books and records provisions, and Goldman Sachs agreed to pay $2.9 billion plus another $400 million in civil penalties. And interesting to note that amount basically covers Goldman Sachs' net profits for 1 quarter. So imagine if your company's net profits for a quarter were completely wiped out. It's pretty significant. Pfizer, SEC charged them for illegal payments made by its subsidiaries to foreign officials all over the world: Bulgaria, China, Croatia, Czech Republic, Russia, Serbia. They did that to obtain regulatory approvals and sales and increase prescriptions to their products. So Pfizer had also acquired another company called Wyeth LLC, which had been charged with their own FCP violations. And so you have to be careful about that as well when you're acquiring other companies, because Pfizer had to pay a combined settlement of $45 million to cover their own violations and Wyeth's violations. 3M was an interesting one. 3M's Chinese subsidiary arranged for Chinese government officials to come to the U.S. and attend overseas conferences, educational events, and healthcare facility visits. They said it was for marketing and outreach efforts, but the arrangements were found to be a pretext to provide Chinese government officials with overseas travel and tourism in order to induce them to purchase 3M products. Arrangements included guided tours, shopping visits, day trips to nearby sites, and other leisure activities. Tours were often scheduled at the same time as company events. So they did schedule company events for these people to come to, but then they would schedule tours for them to go to at the same time. And of course, none of the government officials came to the company marketing events, but they went on these tours. 3M subsidiary, and so this is a good example of where it wasn't 3M directly doing this, but it was a Chinese company owned by 3M. They paid nearly $1 million to fund at least 24 trips for Chinese officials, and the SEC found violations of the books and records and internal accounting controls. 3M agreed to pay disgorgement plus interest of about $4.5 million and a $2 million civil penalty. Nu Skin, right here in our own backyard, they're found to have violated the internal controls and books and records provisions. They had a Chinese subsidiary making payments to a charity to obtain influence of a high-ranking Chinese Communist Party official to impact an ongoing investigation. There's an investigation of Nu Skin China where they were going to be fined $481,000, but Nu Skin China was able to get the party official to step in, and those charges were dropped. So Nu Skin did cooperate with, at least Nu Skin US cooperated with the officials here in the US, and because of that, the SEC accepted a low offer from them, and because of their remedial actions that they took to set up policies for the future. But the SEC still ordered $431,000 in disgorgement, $34,000 in interest, and a civil penalty of $300,000 in that case. And go ahead, next slide. So this map, it represents U.S. enforcement of FCPA since 1977. Darker red appears, the darker red of country appears, the larger the total penalties assessed for violations in that country. There's been more than 500 cases covering activity in more than 100 countries since 1977. Interesting here is Nigeria has been a big target, but also since this map was made, enforcement has increased significantly in Brazil, China, and Uzbekistan. Next slide. All right, most of you know who this is. Few people are as notorious in the news right now as Hunter Biden. He's been accused of crimes, particularly by conservatives, in a bid to tie actions to his father. But what are those allegations, and do they hold steam? There's two allegations brought up most often, which include the Foreign Agents Registration Act, FARA, and the FCPA. As for FARA, that's not our topic today, so I won't go into that. But whatever your political thoughts set aside, it's clear that Hunter Biden was doing business in foreign countries, which puts him at risk for an FCPA violation, just like any other company doing business overseas. According to released text messages from Hunter's business partner, Tony Bobulinski, Hunter told Tony, "We don't want to have to register as foreign agents under the FCPA, which is much more expansive than people who should know choose not to know." Some people believe Hunter was really referring to FARA, as that's the law that requires foreign agent registration. However, the text at least shows that Hunter had the FCPA on his mind. A document filed with Hunter's rejected plea agreement in 2017 showed that he earned just under $1 million from a company he formed with a Chinese CEO, $664,000 from a Chinese infrastructure company, and $500,000 in director's fees from Burisma, which operated in the Ukraine. At the time, Hunter and his associates were pursuing a deal with Chinese tycoon Yi Jianming, chairman of a Chinese company CEFC, who is coincidentally now under detention in China on charges of bribery. The Senate GOP report concluded that CEFC had sent nearly $5 million to a company tied to Hunter called Hudson West 3. So with all this money being sent to Hunter, was it an FCPA violation? I would say no. And the reason for that is an FCPA violation would have to work the other way around. Even if they were sending bribes to Hunter to have access to his dad, that's not what the FCPA violation would be. Instead, Hunter would have to be sending money or giving other bribes to the foreign officials for an advantage there. And so it doesn't work the other way around where they're sending bribes to the US. One way Hunter could still be implicated in an FCPA violation is if evidence were to arise showing Hunter used access to his father as a bribe to foreign officials to gain business. But so far, there's no record of that that's been shown. Hunter's former business partner, Devin Archer, did testify, however, that Hunter gave the Ukrainian energy company Burisma the illusion of access to his father. But without more, I don't think the illusion of access would be sufficient to constitute an FCPA violation. Another way is if facts were to arise that show that people Hunter was working with overseas engaged in bribery as his agents, even if he didn't directly know about it. If they were agents of his or subsidiaries of his companies, and they engaged in bribery, then that could implicate his companies just like any other company here in the U.S. So one officer of CEFC who Hunter likely would have worked with, Patrick Ho, was charged by the Justice Department in 2017 under FCPA charges. And the first call he made after his arrest was to Jim Biden, which is Hunter Biden's uncle. And Jim suggested that the call was meant for Hunter. So could there be some tie there? Maybe, but nothing's been shown at this point that would implicate Hunter in those same FCPA charges. So if you're a Biden supporter, you're in luck. I don't think there's any facts that would now appear to implicate Hunter or the president in any FCPA violations. But it is an interesting case study as well as all the others that we've gone over. Next slide. All right, now we have some time for questions. If anyone has some questions, you can always contact any of us at any time if you have questions in the future. Our phone numbers and emails are up there on the screen.
Hey folks, I know we're getting close to the hour, but this has been really enlightening. I appreciate you sharing all your expertise today. I know you've been answering some questions in the chat as we've gone along, so appreciate that. I'd say, yeah, for those on the call, jot down these email addresses and reach out directly. For the sake of time, I don't think we have time for questions today, but thank you again. And yeah, we hope to see everybody next time.
Thanks, Rob.
All right. Thanks, Theo. Thanks, Matt.